Hello and welcome to the Minimum Competence episode for Tuesday, June 10th, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, we have Google's antitrust fight in Mexico, big loopholes in Texas housing reform, and the IRS eyeing AI with troubling echoes of Dutch enforcement failure. Let's remember always that all of us are descended from immigrants and revolutionists, and read today's legal news. On this day in legal history, June 10th, 1946, the U.S. Supreme Court decided Colegrove v. Green, upholding an Illinois congressional districting scheme that created dramatically uneven district populations. The plaintiffs argued the map diluted votes by packing more people into some districts than others, violating principles of equal representation. However, the court, in a plurality opinion by Justice Felix Frankfurter, declined to intervene. Frankfurter emphasized that districting was a political question and not within the judiciary's purview to resolve. This ruling effectively insulated redistricting practices from federal judicial review and left voters in malapportioned districts without a constitutional remedy. Frankfurter's view was rooted in judicial restraint, warning against courts becoming embroiled in political thickets. But critics argued that this deference allowed entrenched political interests to ignore population shifts and disenfranchise urban voters. The decision stood until 1962 when the court reversed course in Baker v. Carr. There, the justices held that federal courts could indeed hear redistricting cases under the Equal Protection Clause, ushering in the one-person, one-vote era. Colegrove thus marked the high watermark of the political question doctrine's use in avoiding electoral oversight, a stance the court ultimately abandoned. Mexico's antitrust regulator is poised to issue a ruling by June 17th on whether Google engaged in monopolistic practices in the country's digital advertising market. If found guilty, the tech giant could face a fine amounting to 8% of its annual Mexican revenue, potentially one of the largest ever imposed by the agency. The case began in 2020 and moved into a trial phase last year, with a key hearing held on May 20th. Mexican regulators claim Google built an illegal monopoly and has obtained financial data from the Mexican Tax Authority as part of its investigation. Google, which hasn't disclosed Mexico's specific revenue but reported $20.4 billion for the broader Other Americas region in 2024, could seek an injunction to delay the ruling pending judicial review. This would parallel similar antitrust issues the company faces in the U.S., where courts have ruled against its dominance in search and advertising technologies. Adding to tensions, President Claudia Sheinbaum has sued Google for renaming the Gulf of Mexico to Gulf of America for U.S. users, a move she claims Google had no authority to make. The long-standing antitrust case has drawn political attention, with lawmakers urging Mexican officials to act. And in my column for Bloomberg Tax this week, I talk a bit about Texas housing policy. Texas has taken a meaningful first step toward curbing abuse in its affordable housing tax system with HB 21, but the new law leaves major gaps that developers could still exploit. Signed by Governor Greg Abbott, HB 21 aims to end long-term tax breaks for projects that offer little true affordability to homeowners. However, the bill's reliance on area median income, or AMI, to define affordability creates a loophole. In wealthy areas, rent set at 80% of AMI can be as high as typical market rates, making the term affordable really misleading. The law requires that half of all units be reserved for low-income tenants, but without adjusting for local wage realities, this standard fails to address the needs of those most burdened by housing costs. Worse still, enforcement is delayed, audits may take years, and there is no mechanism to reclaim tax benefits already received by developers who fall out of compliance. This makes upfront compliance optional in practice, not mandatory. While HB 21 mandates parity in amenities between market rate and affordable units, this provision seems symbolic without robust inspection. The lack of a tax credit clawback, something present in federal programs like the Low-Income Housing Tax Credit, further weakens accountability. The bill's structure could dissuade honest developers who face unclear or burdensome requirements, while allowing bad actors to benefit before facing any scrutiny. Texas risks ending exploitative deals without fostering enough viable new ones, exacerbating its housing shortage. And a double dose of me this week. I write for Weekend Insights for Bloomberg Tax. As the push for government efficiency grows, the IRS is considering using artificial intelligence to identify non-compliant taxpayers based on past audit outcomes. While this might sound like a smart upgrade, history offers a sober warning. The Netherlands tried something similar, using AI to spot fraud in childcare benefits, and it ended in a national scandal. The algorithm disproportionately targeted minority families, human reviewers failed to intervene, and the fallout brought down the government. A recent Treasury Inspector General for Tax Administration, or TIGTA, report suggests the IRS could, quote, leverage examination results to improve case selection algorithms. But this raises red flags. IRS audit history isn't neutral. A 2023 joint study by Stanford and the Treasury Department found that black taxpayers were audited up to 4.7 times more than others. especially when claiming the earned income tax credit. That disparity likely came from algorithmic choices aimed at efficiency, not fairness. If the IRS trains AI on this unfiltered historical data, it risks cementing and expanding past biases into future audits. AI could be a powerful tool, but only if accompanied by key safeguards. First, training data must be rigorously reviewed to eliminate bias. Second, model decisions must be transparent so we understand how and why certain cases are flagged. And third, human reviewers must be actively trained and authorized to question and override algorithmic decisions. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in the story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, we came to America either ourselves or in the person of our ancestors to escape tyranny. We came to find liberty.